This video will cover the process and general timelines for divorce and suit affecting parent-child relationship cases, also known as child custody cases. The information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, materials available on this site are for general information purposes only. Viewers should contact an attorney to obtain advice with respect to any particular legal matter. To begin a case, you will need to start by filing either a petition or motion as appropriate for your case. This initial document will list the requests you are making to the court. Depending on the type of petition or motion you file, you may be required to file additional supporting documents or documents required by your local court. When filing your case, there will be filing fees. If you are unable to afford filing fees and court costs, you will need to file a statement of inability to afford payment of court costs. You may file either in person at your local district clerk's office or electronically through efile.txcourts.gov. If you decide to file electronically, it may take some time for the district clerk to accept or reject the filings. If filing electronically, you may also receive an invoice if your statement of inability to afford payment of court costs is not accepted. If you are filing a divorce case, there is a 60-day waiting period that is required by law before the court can finalize your divorce. This waiting period begins when the original petition for divorce is filed. Please keep in mind that all other filings required and procedures that must be completed before the divorce can be finalized. It is common that this will take more than 60 days. Emergency matters can be discussed at pretrial hearings. Next, the respondent must be given notice of the initiated suit. This is generally done in person. If personal service is not possible, there are other methods to serve the respondent. Once the respondent is served, they have about 20 days to file an answer. If the respondent does not file an answer by the end of their answer period, this may result in the court making decisions based on one person's requests to the court. This is called a default. If the respondent files an answer, then they are entitled to notice of hearings and further action in the case. This means you will need to serve the respondent with any further filings in the case. Services for further filings does not have to be in person. Next are pretrial hearings. If there is an emergency or important matters that need to be discussed before finalizing the case, you will need to ask for relief in your initial filing or a later motion. You may need to file a motion and follow the court's procedures for requesting a hearing on these issues. Please note that if your case involves children, other parties such as a guardian ad litem or an attorney ad litem may be assigned to your case in a temporary orders hearing. Their job is to help the court decide what is in the best interest of the children. Sometimes one party will serve the other party with a request for discovery. This may include requests for production, requests for disclosure, requests for admissions, interrogatories, and expert witness disclosures. If a party is served with one of these discovery requests, they have 30 days from when they are served to respond. The party also has a duty to provide any additional information or updates if it becomes available. All discovery must be completed no later than 30 days before the final hearing. If you plan to use an expert witness, you must tell the other party 120 days before the trial. Throughout your case, you may try to come to an agreement with the other party on issues in your case. If you are able to come to an agreement, you will need to fill out and sign an agreed final decree or order with the terms you're agreeing on. The court is not under any obligation to accept your agreement if issues such as child support or spousal support in your agreement do not meet legal standards in Texas. Some courts may require mediation between the parties before continuing proceedings. If there is a finding of family violence in a case, you may be able to waive the mediation requirement. In mediation, you may come to an agreement on all, part, or none of the issues in your case. Whatever is not agreed on will need to be decided by the judge at trial. If you are able to come to part or full agreement, the parties will sign a mediated settlement agreement. Once the mediated settlement agreement is signed, the parties cannot go back on their agreements. If the other party never responded to the lawsuit, a party will need to file additional documents to show the court that they tried to alert the other party to the suit before setting a hearing. Please make sure to check with your local district clerk that you have filed all the required documents in your case. Finally, trial. If the parties cannot come to an agreement, the case must be set for trial. The parties can agree on a hearing date, or one party can give notice to the other party of the hearing date. If the hearing date is not agreed, the party setting the hearing must give the other party at least 45 days' notice. A final decree of divorce is approved and signed. After a divorce has been granted, the parties cannot marry another person for at least 30 days. If you think the judgment entered in your case was unfair or incorrect, get legal advice from an attorney immediately because there are time-sensitive deadlines to take any additional legal action, like appealing your order.
Criminal trials in Texas differ in length of time. Several things can affect how long the process can take: the type and severity of the crime, the size of the court's docket, and whether the defendant is in jail or out on bond. Offenses can be state or federal offenses. This presentation will explain the general criminal process for state-level offenses in Texas. From arrest to final disposition by dismissal, plea, conviction, and appeal, the process can take anywhere from 6 months to a few years. Let's break down what happens during this time. First, a complaint is made to or by law enforcement, and there is probable cause that the law has been violated in some way. If there is probable cause for an arrest and the alleged offender is present, they can be arrested on the spot. If the alleged offender is not present, an officer will prepare a probable cause affidavit and take it to a judge for review. If the judge agrees with the officer, then a warrant for arrest is issued. Once the alleged is arrested, they are booked and processed into either a holding cell or jail until they go in front of the judge. Usually, alleged offenders are brought before a judge within the first 48 hours after being arrested. At this first meeting with the judge tells the alleged offender what the alleged offense is, what level of offense it falls under, and the possible range of punishment for that offense before setting a bond. A bond is an amount of money determined by the court that the arrested person must pay to be released from jail while their criminal case is pending. If the defendant does not pay the bond, they remain in jail. In most cases, if an alleged offender remains in jail, the prosecutor must file the charges in a shorter time frame. After the alleged offender has been arrested, the arresting agency will send the evidence and report they have created to the appropriate prosecutor's office for screening. Most prosecutor offices have a section of their office dedicated to screening incoming cases to decide whether they accept or decline the case for prosecution. In misdemeanor cases, once the case has been accepted for prosecution, the case is assigned to a court to begin the formal criminal court process. If the defendant has been charged with a felony crime, the case must also be presented to a grand jury to review before the formal criminal court process can begin. A grand jury is a group of citizens who briefly review the information provided by the police and prosecutors. A grand jury does not determine guilt or innocence. They may only determine if there is enough evidence to believe that a crime could have been committed by this alleged offender. Once the charges are sent to the court, the defendant may be required to appear in court for their arraignment. During arraignment, charges are formally placed against the defendant, and they are provided a copy of the charging instrument, which formally or officially accuses someone of committing a crime. At the arraignment, the defendant will also enter their initial plea of guilty or not guilty. If the defendant enters a plea of not guilty, then the court will give the defendant their next court appearance date. After arraignment, there are several court dates before the case is resolved. Throughout the entire process leading to the trial, the prosecution and the defendant may come to a plea bargain or a plea agreement where the defendant agrees to plead guilty to a charge or charges against them. An example of a plea bargain would be that in exchange for pleading guilty or no contest, the defendant may plead a lesser offense or plea bargain for a less severe punishment. Most criminal cases end with some form of plea bargain, which could include probation, deferred probation, jail or prison time, or a combination of these options. If the defendant does not enter a plea bargain, the case will proceed to be scheduled for trial. A trial date may be rescheduled several times before a trial actually happens. During this time, the defendant may still have the option to enter into a plea agreement with the prosecution. As the investigation and preparation for trial continues, the prosecutor may also dismiss the case at any point before the trial if there is not enough evidence to prove the crime beyond a reasonable doubt. Before the trial, the jury is picked. This process is called voir dire or voir dire. Throughout the trial, the jury listens to the evidence and the witnesses. At the end, the jury decides whether the defendant is guilty of the crime. A criminal trial has two parts or phases: the guilt and innocence phase and the punishment phase. The guilt or innocence phase is first. The prosecutor, who represents the state of Texas, must prove the defendant is guilty of all of the elements of the crime listed on the charging instrument. The prosecutor will present evidence and call witnesses. Depending on the crime, a victim or a witness may be asked to testify. The length of a trial depends on the severity and complexity of the crime, how many counts are included in the charge, how much evidence is present, and how many co-defendants are involved. Trials may last a day or up to several weeks. After the prosecution and the defense have presented all their evidence and testimony, the case is sent to the jury for deliberation. This means that they have to talk about the case and decide whether the defendant is guilty or not guilty of all the required elements of the charges. A jury's decision, whether guilty or not guilty, must be a unanimous decision. If one or more of the jurors cannot agree, the jury is hung, and the prosecution will have to decide if they want to continue to prosecute the case and have a brand new trial. If the jury decides that the defendant is guilty, the defendant is convicted, and the case moves to the sentencing or punishment phase. It is usually up to the judge to determine the convicted defendant's punishment. Sentencing may happen on the same day as the guilty verdict or on a different day during a separate hearing to allow a convicted defendant to put their affairs in order before being taken into custody and sent to jail or prison.